Okay, abusia yabema kwabashonko so edeba POG Media so yeremeko political highway ne so highway ne de ensem bebre wo so ayen so ya je pene se be me abidwafo no ahu de eko ene de eba na abusia den na eko so ewo political highway ne so eye NPP MP sa je se omo parliament na omo che se eye A.Markins pa de onye obia nanka deserve senka obeye majority leader na sisi ano omo nu omo ho se omo ma A.Markins eba beye eye majority leader omo sake chimensa bonsu all because of enka parliament ene eye supreme court sense enka ye chimensa bonsu ene wo ha enka sansem we nyina intino omo che se A.Markins ne de majority leader no obeye no onim she say like ahomaso ene e say tintinti ene wababeye no parliament wo na nka kachi mensa bonsu ko ade a enko no nka speaker of parliament enye saa nyoma we entino NPP MPs na kasa ajoin abam Bagbin ameki U-Turn say I expose A.Markins enye asamketo akwa mo che say saa case na ode kokko PM Supreme Court no eye useless enye case ayese enke kokko PM ho a abusia sisi ano MPP MPs na nkasa no omo ejina A.Markins ko so se onko Redraw case no emfree eye Supreme Court wa abusia enye asanketo akra na sisi ano MPP MPs ne so de eye pressure enso ma eye Chief Justice Chukunu abusia enye asanketo akra yensa emombre ne bepese be me abidwafo no be me akona yakwa kotie ensem a ekos na answer na ebekono owo ensem kan bia fa share your comment section mu like na share ma afofro so answer into me enkabi POG Media so and don't forget to click on the notification bell so that any updates be ebe bremo bia no monsa ebitumi akabi madamase.
Early this week, I did an interview with a retired appeals court judge. And he said, on mic, that he really misses Mensa Bonsu. That if Mensa Bonsu was still the majority leader, we would not have come to this. And I've heard many others say that they miss Mensa Bonsu. Because he was adept at negotiation and so on. You understand? He did not push for confrontation where confrontation was avoidable and so on. Perhaps we should all agree with this retired judge of the courts of appeal. I don't want to think that all of this maneuvering is about positioning for the 2024 elections. I don't want to. You understand? But Senna, I'm already beginning to see some signs around the 2024 elections which are extremely worrying. And I hope that this is not one of them. I mean, I was shocked to the marrow when I heard the U.S. Embassy make a statement that those who don't play the game by the rules and so on will be refused visas to the United States of America. What nonsense. The United States of America is not heaven. So if people don't go to the United States of America, so what? The U.S. has no authority to decide the legitimacy of what we do as Ghanaians, how we hold our elections. So the U.S. has no role to play in it. Those decisions must be made by the Ghanaian people. Because we do know that wherever the U.S. has made such interventions, it has only led to chaos. Look at Venezuela. Look at how the people of Venezuela are suffering because of this needless intervention by the United States of America. Sometimes it's not even about elections. It's about political choices which are not necessarily about elections. Look at Cuba. Look at what they've done to Cuba. million people have died in Iraq. We are not expecting the United States of America to decide for us what processes we follow or we do not follow. The U.S. has no business, and they should stay out of this. The people of Ghana have the capacity to decide for themselves whether elections have been rigged or not. And when elections are rigged, the people of Ghana who fought and defeated classical colonialism, who have changed governments many times and so on, will do it again. Why? The U.S. believes in democracy. It is the belief of the U.S. in democracy which led it to sponsor the 1966 coup against Kwame Nkrumah. Is that what we are being told? And indeed, all the problems we have today can be traced, or most of the problems can be traced to the 1966 coup. The U.S. The U.S. which was involved in the assassination of Patrice Lumumba because of his political views and so on. It has no role to play in Ghana, no role to play in Africa. They should shut up and leave us alone.
Thank you.
And it is not my intention this morning to repeat all the comments that I've made before. What I'd like to emphasize that it is only in Cuckoo's Land that the assumption can be made that a Supreme Court decision necessarily stops all disputes. It doesn't. As we speak here, as we sit here, the conflict in Boku is raging. And the conflict in Boku is raging in spite of numerous Supreme Court decisions. So Boku should tell us very clearly that the assumption that the Supreme Court is the final arbiter in legal disputes and so on cannot be understood that once the Supreme Court makes a decision, disputes vanish, conflicts vanish, and so on. It's not true. Boku is the clearest example. Now, the second point that I like to make, and this point has been made by several people, it's not my original thought, is simply that decisions of the Supreme Court have to have a certain level of consistency. Because if they fail to have a certain level of consistency, what it would then mean to ordinary mortals like me and so on, that every judge and any judge can decide anything, and that the law itself has no consistency. In which case, the interpretation of the law will be seen as a biased enterprise. And once you begin to see that the interpretation of the law is a biased enterprise, and is not rooted in principle and so on, we create conditions for general anarchy in our society. Now, why do I say this? I say this because that day when I listened to the Supreme Court judges, those who were empaneled, when I listened to them, one of the reasons they stated was that the Supreme Court has jurisdiction, appellate jurisdiction, in all judicial decisions. And Senna, I was so shocked. Because the Supreme Court of Ghana has in an earlier case decided that when it comes to election disputes, the Supreme Court does not have appellate jurisdiction. The Supreme Court had told us that if you look at the relevant sections of the Constitution, articles in the Constitution, which deals with, election disputes are to be heard by the High Court. And that the Constitution expressly says that if parties in the dispute are not satisfied, they may appeal to the Court of Appeal. And that because the Supreme Court is not expressly stated in the Constitution, the Supreme Court has no jurisdiction when it comes to election disputes. So at least in one instance, the Supreme Court has told us that its jurisdiction is not over all matters or all decisions that are taken by the judiciary or arms of the judiciary and so on. So how come that the Supreme Court is taking this decision? And the shock of it is that it's a unanimous decision. Okay? The shock of it all is that it's a unanimous decision. So the question that I'm asking is that if the same panel which had heard the previous case had heard this case, what would the verdict have been? And if the verdict would have been different, what is the message we are sending to the Ghanaian people? That the decision of the court depends on who are members of the panel. That's a bit worrisome, okay? And many people have made this point, including lawyers of repute and so on. They've made this point and they've made it very, very strongly. Now, the other thing that I find extremely strange is the demeanor of some of the judges. And the judges themselves will tell you that demeanor is important. When they're trying cases, one of the things they take into account is the demeanor of witnesses who appear before them, the demeanor of parties to the dispute, and the demeanor of accused persons and so on. Is an important consideration in law. So I'm not making it up. Now, if you look at the demeanor of some of the panel members, it is worrying. And indeed, I read one newspaper which made the point about the anger displayed by the Chief Justice. And I'm saying that Chief Justice, judge of the Supreme Court, a matter of constitutional interpretation has been placed before you. Where does the anger come from? How can you be angry? Indeed, you are not expected to display anger, which is an emotion. You understand? So that anger itself raises many substantial questions. And it was displayed, in ways which I felt as a citizen of this country were unpalatable. You understand? For example, I heard the Chief Justice say, in a demeanor which can only be seen as anger, that how come, where is this country going to, and so on? How come that in the midst of all that is happening, Parliament is not sitting? There was nothing before the court about whether Parliament should sit or not sit. The issue before the court was not about Parliament sitting or not sitting. You understand? And yet, she made this comment in open court. And I think that comment, judicial notice can be taken of that comment. Then there was a point also where she actually went into exchanges about why the Speaker had not filed, or the lawyers of the Speaker had not filed their responses, to the case which had been filed by the plaintiffs. And I'm a layman. I didn't go to law school. I'm sitting at home. And I'm saying that, look, what am I missing? The lawyers of the Speaker had gone to court to ask the Supreme Court to set aside decisions that it had made earlier because the processes were legally invalid. That's the case they took to the Supreme Court. Now, that carries an assumption that as far as they were concerned, there was nothing illegal and substantive before the Supreme Court. How can they answer? Master, how can they answer when they think that, properly speaking, legally speaking, constitutionally speaking, there was nothing valid before the court? So their case before the court to set aside the decisions of the court is a response. It is only after that has been dealt with that they may or may not file, responses to the original case before the Supreme Court. So I was really surprised. And then instantly, the Chief Justice poses a question to the lead counsel for the Speaker and says, can we go ahead without you? Now, this is the same court which had insisted that anybody whose case is being heard needs to be given a hearing. Being given a hearing was so important for this panel. And yet, at the same time, when it came to the Speaker, they wanted to know whether they could go ahead without the Speaker. In fact, they pressed upon the Speaker's lawyers that they could vacate their rights to make an appearance, to participate in the decision. And I found that exceedingly strange. Now, Senna, I think that there are some principles which ought to be made very, very clear to all public servants, including those who sit on the bench. Okay? Why do we have a Supreme Court? Why do we have Supreme Court judges? One, we have a Supreme Court and its judges only because all the 32 million people of Ghana cannot sit in judgment in cases. Okay? So our power, our right to judge, to interpret the Constitution and so on, is delegated to some people to act on our behalf. I hope you understand what I'm saying. So anytime the Supreme Court sits and makes a decision, it is making that decision in our name, in the name of the people of Ghana. Anytime the Supreme Court makes a decision, that decision rightly is made in the name of the people of Ghana. Okay? Now, the Supreme Court itself is a creation of the 1992 Constitution. Okay. Now, this 1992 Constitution did not fall from heaven like the tablet on which Moses' 10 Commandments were found. It was political struggles, political negotiations, and so on, which led to the crafting of the 1992 Constitution. And in the process of fighting for change, fighting for a return to limited democracy, what others will refer to as bourgeois democracy, people died. People lost their lives in that struggle. People suffered imprisonment. Many, many sacrifices were made in order to craft that Constitution. So at every stage, we, including the Supreme Court judges, should be asking ourselves whether or not decisions which are being made today are in tune with all those who sacrifice so much, and so on, their aspirations. Is this what they were expecting? You understand? Is this outcomes for which they laid down their lives? Are these the outcomes for which people suffered so much in order to craft the 1992 Constitution? Now, the Supreme Court has made its decision. Okay. And I think that it is possible for us to look at the practical outcomes. Possible outcomes. I've seen a letter written by a young man to the Speaker of Parliament, in which this young man is actually warning the Speaker of Parliament that if he doesn't accept the decisions of the Supreme Court, it would amount to a high crime for which he can be impeached, and so on, I mean, obviously. Now, I'm sitting at home reading this letter, and I'm wondering, indeed, Parliament would make its decision. It is possible for the Speaker to convene Parliament on the 7th of November and announce the decision of the court, and to tell Parliament that this is the decision of the court. What do? Parliament can take a decision on it. Okay. Now, if Parliament doesn't have a quorum, that decision would not be taken. Parliament needs a quorum in order to be able to take that decision. And if Parliament does not have a quorum and can therefore not take that decision, it means that Parliament would not continue to sit. So the Supreme Court decision would actually not be implemented. Not because the Speaker wants it or does not want it, but simply because the House would not have the quorum for making decisions. That's number one. Let us say that the Speaker goes to Parliament and says that I make those orders, I'm withdrawing those orders. That's another possibility. And therefore, the NPP group, not caucus, the NPP group in Parliament, I'll explain that, the NPP group, not caucus, is the majority. If the Speaker were to make that declaration in Parliament, and the NDC side decides to walk out, will Parliament be able to sit? What will be the effect of the decision of the Supreme Court when the NDC group decides to walk out, to protest, and so on? And the NDC group has a right of protest, the right to protest. If they decide to protest in that matter, that decision of the Supreme Court would mean nothing, would have no effect, and so on. Okay. Now, let us also assume that the Speaker decides to defer the Supreme Court. How is the Supreme Court going to enforce its decision? Is the Supreme Court going to order the police to arrest the Speaker? Is the Speaker going to be arrested? Is the Speaker going to be imprisoned? And what will be the consequences of that for the work in Parliament and for the practice of this limited so-called bourgeois democracy in our country, if such an order were to issue? And in any case, if such an order were to issue, will the security forces, perhaps the police, effect that order? So what will be the consequences for all of us? Now, let us say that the Supreme Court then decides to charge the Speaker with contempt for not respecting his decisions or for obstructing his work. Now, if you read the Constitution very, very carefully, Parliament itself can also hold all citizens, including panel members of the Supreme Court, in contempt. So what if the Speaker also cites the panel members for contempt? What then happens? I hope you are getting the picture. What then happens? What crisis would we have created? And what are the options for getting out of this crisis? Now, the point ought to be made that Parliament as an institution is a place for debate. It's a place for reaching compromises. It's a place for negotiations and so on. You understand? That is the nature of Parliament. Now, have we come to the point where Parliament as a forum for debate and negotiations no longer exists? Have we come to that point? Have we come to that point where Parliament as a place for negotiations no longer exists? And so on. And if we come to that point, what is the value of this democracy and so on? You know, these are concrete questions which I think that all of us, you know, need to answer. Okay. Now, I've made this point also about minority caucus and majority caucus and so on. And interestingly, the Supreme Court itself made reference to a minority caucus and a majority caucus. And I found it extremely strange. Now, because what happened in Parliament after the 2020 elections is that we had a hung Parliament. A Parliament in which there was no majority and there was no minority. NPP had 137 members of Parliament and NDC had 137 members of Parliament with one independent candidate. So the NPP caucus could not be the majority and the NDC caucus could not be the majority. So some decisions had to be made. Now, strangely, and I say strangely because I disagreed with the Speaker's ruling. Okay. The Speaker came to the conclusion that instead of having caucuses of parties, they should have groups. And the Speaker decided that the independent member of Parliament could join the NPP MPs in order to form the majority group, not caucus. Now, why did the Speaker do that? The Speaker did that because of the very, very provisions of the Constitution that we are talking about, which prevent crossing carpet.
Abusia, we ne ensema ekoso our political highway. So Che Mensa Bonsu, NSCA, NPP majority no, omo afina enye asem ketwa kra, because they almost say after A.Markins say useless. The oye onim the oye our parliament. So you see ano omo che say omo afi Che Mensa Bonsu, ka Che Mensa Bonsu and kone Bagbin crampo the negotiations no na kasa amanka bibia ababe to na A.Markins the osore ya just say onim bonia one Chief Justice and as Supreme Court judges no or moyens no or sorry ya case any case ba Lord ya papa PM Supreme Court abusia we ne ensema ekoso our political highway so every abidafo as say omoje pene kokoti sa odu di mai aha POG Media so madam ase